How is that stakeholder capitalism working out for you?
How is it working for Johnson & Johnson? It's one of the greatest honors of my life.
I see where Johnson & Johnson has joined with a number of other good American companies. J.P. Morgan, he's not a company. Mr. Colin Kaepernick on his issue of police brutality. Procter & Gamble, Facebook, Apple, y'all pledged $50 billion to, quote, be a force for social change and fight injustice. $50 billion is a lot of money. How is that commitment consistent with what you're asking us to do here today?
Sir, I'm not aware of the particular commitment you're referencing, but I could say dispositively.
It's got to be right.
I could say dispositively that the consistency is, in the end, to ensure that each and every act that the company takes is consistent with our credo. Okay. And our credo puts the public and our patients first.
Right.
Hey everyone, welcome back to Hot News Today. Today's video dives into a fiery exchange from a recent Senate Judiciary hearing. Senator John Kennedy questioned Johnson & Johnson's Erik Haas and legal professor Lindsey Parikh on corporate accountability, the Texas two-step bankruptcy loophole, and the role of Congress. Let's break down what it means for corporate America and the legal system.
Let me ask the professor a few basic questions, because I'm still learning about this issue. Johnson & Johnson took it... Oh, before I do, I forgot to ask you one question. How many Talc cases have you tried to verdict?
There have been 42 cases that have gone to verdict. Of those, we have prevailed in 32.
Okay, so you lost 10.
Yes.
Okay, and what were the total damages in the 10 that you lost?
The damages ranged dramatically.
Just give me a total.
I don't know the total. I can give you a proxy. The highest one was in the billions.
Okay. All right, Professor, I don't want to just pick on Johnson & Johnson, but they're the one here. Let me pick on Georgia Pacific, okay? I don't want to pick on anybody. I'm learning on this issue, but let's call them Corporation A gets sued with respect to mass torts. They spin off the liabilities to a shell corporation, and that shell corporation files Chapter 11 bankruptcy, right?
Sure.
Is that legal under the bankruptcy code?
Is that legal? The code does not restrict that necessarily. Courts have found that there are a variety of bases to reject that sort of action. So courts have been pretty active in this space.
Senator Kennedy turns to Erik Haas from Johnson & Johnson. He asks a question hitting at corporate ethics. You're with Johnson & Johnson, right? How is stakeholder capitalism working out for you? No softballs here. Haas deflects, calling his role an honor. But Kennedy isn't here for corporate PR. J&DJ pledged $50 billion to fight social injustice. Noble, right? How is that consistent with today's ask? That's where things get uncomfortable. Kennedy then hits a nerve: the Talc lawsuits. How many Talc cases have gone to verdict? 42. How many have you lost? 10. Total damages in those? The highest was in the billions. So Johnson & Johnson has a big problem. What do? According to Kennedy, they spin off liabilities into a shell company and file Chapter 11 bankruptcy, the now infamous Texas two-step. If you're not familiar, that's when a company dodges massive lawsuit payouts by creating a new entity to absorb liability and file for bankruptcy. All legal, technically, but is it ethical? Next up, Professor Lindsey Parikh. Kennedy throws another fastball. Is that legal under the bankruptcy code? Parikh's answer is cautious but clear. Courts are split. Some judges allow it, others throw it out. There's no national consensus, and that inconsistency invites forum shopping. Parikh suggests Congress needs to amend parts of the bankruptcy code. Now let's get back to it. Kennedy circles back with a sarcastic yet sharp observation. You just had a golden opportunity to answer my question, and you didn't do it. He's exposing the gaps in oversight. These corporations are playing legal chess. His final push: what should Congress actually do? Professor Parikh lays it out. Amend 524, G, clarify the code, and fix how future claimants are chosen.
I mean, and what are you asking us to do today? Let me start with Mr. Haas again. What are you asking us to do today?
The ask from our perspective to Congress would be to make uniform that very issue you just identified. What is the standard with respect to dismissing a case? Now, there's a distinction between the propriety of a Texas two-step, let's call that. It's a divisional merger statute, and the question of what is a standard that you apply when you dismiss a case. Our case was not dismissed because of anything to do with the Texas two-step. Nobody challenged the Texas two-step in our case. In fact,
Mr. Haas, you just had a golden opportunity to answer my question. Let me ask you, Mr. Parikh, and you didn't do it. Professor, tell me what you think we should do today. What you think Congress would do.
I think there are very large issues here. I think, as I mentioned before, 524G needs to be amended to.
This hearing wasn't just political theater. It was a rare moment of raw accountability. Senator Kennedy exposed how big corporations may be abusing the legal system to dodge responsibility. Whether or not Congress acts is another story, but one thing's clear: the system is overdue for reform. Like, subscribe, and turn on that notification bell so you don't miss future videos. Thanks for watching. I'll see you in the next one.